Good morning, everyone. It's a pleasure to welcome everyone to the 18th meeting of the Public Utility Commission for calendar year 2014, and would ask that you join us in the Pledge of Allegiance here this morning. Pledge of allegiance to the flag of the United States of America, and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. The first item on this morning's agenda is the approval of the minutes of the October 2nd public meeting. It's a pleasure to recognize Commissioner Cawley as editor of the minutes. Commissioner Cawley.
Thank you, Chairman, and good morning, everyone. I have reviewed the minutes of our October 2nd public meeting, and I move that they be adopted as submitted.
Second. Any discussion? Any objections? Hearing none, the minutes are approved as submitted here this morning, and it's a pleasure to welcome to the podium to commence with public meeting agenda items, Ms. Cheryl Walker-Davis. Good morning, Cheryl.
Good morning, Mr. Chairman. Good morning, Commissioners.
Good morning.
May it please this Honorable Commission, on behalf of your various offices and bureaus, we present for your consideration and disposition the following agenda items, commencing this morning with matters on behalf of the Bureau of Consumer Services. It is recommended with regard to the first item that the Commission adopt the staff recommendation pertaining to the First Energy petitions to amend its universal service and energy conservation plans for its various companies, noting the statement of Commissioner Brown.
So moved. Second. I'd like to recognize Commissioner Brown for purposes of her statement. Commissioner Brown.
Thank you, Mr. Chairman. I just wanted to take the opportunity to commend First Energy companies for making these modifications to their universal service and energy conservation plans. Reducing customer participation thresholds will increase the availability of these programs to customers this heating season. In addition, allowing improved coordination between the EDCs and the other weatherization programs will promote efficiencies in the implementation of these programs throughout the company's service territories. Thank you.
Thank you, Commissioner Brown. Any further discussion? Any objections? Hearing none, the motion passes unanimously.
It is recommended that the Commission adopt the staff recommendation with regard to the Philadelphia Gas Works Universal Service and Energy Conservation Plan for 2014 to 2016.
So moved. Second. Any discussion? Any objections? Hearing none, the motion passes unanimously.
Turning now to matters presented on behalf of the Office of Special Assistance, commencing on page 2. It is recommended that the Commission adopt the first item with regard to the petitions for reconsideration in the interconnection arbitration proceeding involving Core Communications and Windstream, Pennsylvania, noting your statement, Mr. Chairman, as well as the statement of Commissioner Brown.
So moved. Second. I'd like to just have my conflict statement entered into the record here this morning to advise the Commission that one of my staff members, Norm Kennard, served as counsel of record for one of the parties involved in this case. However, in this particular matter, he did not advise me on this case. And again, I just want to have this conflict statement entered into the record and now recognize Commissioner Brown for purposes of her statement. Commissioner Brown.
Thank you. I'd like to have my comments submitted for the record, but I just wanted to summarize my statement. Because this case has been in litigation for a number of years, the Commission, by secretarial letter issued on October 4, 2012, asked the parties to address the impact that the FCC's ICC-USF order of November 2011 had on the matter. In response, Core and Windstream filed responsive comments. Today's recommended disposition of the case ignores those comments as being beyond the scope of the case. I disagree. The comments filed by both Core and Windstream in response to our October 4, 2012 secretarial letter address the same issues discussed in the ICC-USF order. Those issues include the rating of traffic, points of interconnection, and VoIP. Due process is not violated by considering the parties' views on these issues given the years of protracted litigation. The recommended disposition of this case points to no provision in the ISP remand order or the ICC-USF order for its results. I note that the FCC's interpretation of the law on these issues is the most recent precedent and has withstood appellant scrutiny. Therefore, the Commission should follow this precedent. It is not logical to selectively impose a bill and keep rate of 0 by citing older precedent. For these reasons, I respectfully dissent.
So noted. Any further discussion on this case?
I also wish to be recorded as voting no.
So noted. We'll note the objections here this morning. The motion passes 3-2, noting the dissenting statement of Commissioner Brown and Commissioner Cawley.
Continuing with the presentation of items on behalf of the Office of Special Assistance in omnibus fashion, we recommend the adoption of the remaining item on page 2 pertaining to the application proceeding of Your Way Transport, Inc., as well as all items appearing on pages 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18, and 19 through and including the proceeding involving the investigation and enforcement versus Gary A. Ladigan.
So moved. Second. Any discussion? Any objections? Hearing none, the motion passes unanimously, and excellent job with your numerical ordering.
We've been very busy, Mr. Chairman. Continuing on page 20, with regard to the matter involving John R. Evans, Small Business Advocate versus First Energy Solutions Corporation, there's the joint motion that you have, Mr. Chairman, along with Vice Chairman Coleman.
I'd like to have our joint motion entered into the record here this morning. Before the Commission for consideration and disposition is the petition for interlocutory review and answers to material questions filed on August 8th by First Energy Solutions. The petition was filed during the pendency of the OSBA's petition for declaratory order that was filed on May 15th of 2014. The OSBA's petition asked the Commission to prevent FES from recovering certain charges from small business customers pursuant to electricity supply contracts. We are of the opinion here this morning that in doing so, the OSBA misapprehends the Commission's jurisdiction over retail electricity generation supply contracts. Thus, we believe it is prudent here this morning that the Commission exercise its discretion to not address the merits of the petition for a declaratory order. It is a basic tenet of public utility law that the Commission only has those powers that are enumerated to it. A review of the Commission's authority makes it clear to us that the jurisdiction does not extend to interpreting the terms and conditions of a contract between an EGS and a customer to determine whether a breach has occurred or setting the rates an EGS can charge a customer. Instead, the Commission can only assure that an EGS is abiding by the standards of conduct and disclosure, marketing and sales regulations, the contract expiration, change of terms, notice requirements, and the rate billed by an EGS calculated in accordance with those materials. A review of the filing in this matter reveals that the OSBA's initial petition requested the Commission to issue an order declaring that FES is not permitted to recover the cost billed to it by the PJM for ancillary services cost as a pass-through event under the terms of its fixed-price contract. And by the way, this is an outgrowth of the polar vortex that hit in last calendar year. In order to make such a declaration, the Commission would need to interpret language in the FES contract. The Commission has no such authority. While the OSBA does appear to raise issues regarding the marketing of the contracts in question, over which the Commission could have jurisdiction, those issues were not raised until OSBA's brief opposing interlocutory review. This is not enough to change the character of the original request for two reasons. First, allowing the OSBA to raise assertions in its brief that were not raised in its original petition changes the nature of the proceeding, which could negatively impact FES's due process rights. Second, in an inquiry into whether FES violated the Public Utility Code or the Commission's regulations during the marketing of these contracts would be very fact-intensive, and as such is not appropriate raised in the petition for a declaratory order. As a final point of clarification, the Office of Small Business Advocate relied heavily upon our guidelines for use of fixed-price labels for products with a pass-through clause order in asserting its claim. This reliance is misplaced. The contracts implicated by OSBA's petition were entered into prior to the issuance of the fixed-price order. This order was prospective in its effect and made no determination whether contracts that predated its effective date. Further, the fixed-price order did not prohibit EGSs from marketing contracts that include pass-through clauses. Indeed, such a prohibition would exceed the Commission's authority. Rather, pursuant to our mandate to ensure that marketing materials can clearly be understood by customers, the Commission, on a going forward basis, prohibited contracts with pass-through clauses from being marketed as fixed price contracts, meaning fixed means fixed. Therefore, we move that the Commission decline the issue of declaratory order in this contract and that the Office of Special Assistants prepare an opinion in order consistent with this motion.
Second.
Any discussion? Any objections? Hearing none, the joint motion passes unanimously.
With regard to the petition for interlocutory review filed by First Energy Solutions in the proceeding involving First Energy Solution Industrial and Commercial Customer Coalition versus First Energy Solutions Corporation, there again is the joint motion that you have, Mr. Chairman, with Vice Chairman Coleman.
I'd like to have our joint motion entered in the record here this morning. Before the Commission for consideration and disposition is the petition for interlocutory review and answers to material questions filed on August the 8th by First Energy Solutions. First Energy Solutions asked the Commission to answer two questions. First, does the Commission lack subject matter jurisdiction to interpret a provision of an EGS's retail customer supply contract as requested? Second, does the Commission lack of primary jurisdiction require, at a minimum, a stay of the current proceedings pending action, a stay of the current proceedings pending action by a civil court of competent jurisdiction? Due to the uncertainty regarding the Commission's jurisdiction, we believe granting interlocutory review and answering the material questions will provide valuable guidance to both parties and the administrative law judge, thereby expediting the conduct of this proceeding. Material question number 1 should be answered in the positive. It is a basic tenet of the public utility law that the Commission only has those powers that are enumerated to it. A review of the Public Utility Code and related case law makes it clear that the Commission's jurisdiction does not extend to interpreting the terms and conditions of a contract between an EGS and a customer to determine whether the breach of contract has occurred or setting the rates of an EGS that the EGS can charge. On material question number 2, however, it should be answered in the negative, as it is based on a faulty premise that the Commission lacks jurisdiction over the complaint. The FES Industrial and Customer Coalition's complaint raises issues beyond the contract's interpretation. Allegations that FES's actions violated the Public Utility Code and the Commission's regulations are included, namely that FES is required to provide adequate and accurate information to the customers, including commercial and industrial customers, regarding its service. The FES ICCC also raises the issue of whether FES has violated the Commission's regulations regarding FES to be responsible for any fraudulent or deceptive billing acts. Therefore, we believe that the FES ICC complaint has raised issues that are within the jurisdiction of the Commission's purview. As the FES ICC has sufficiently raised issues that implicate the Commission's jurisdiction, this matter should be remanded to the Office of Administrative Law Judge for further review, and therefore we move this morning that the Office of Special Assistants prepare an opinion in order consistent with this motion.
Second.
Any discussion? Any objections? Hearing none, the joint motion passes unanimously.
In the proceeding involving the Attorney General of Pennsylvania and the Office of Consumer Advocate versus Blue Pilot Energy Company, LLC, and the petition for interlocutory review there filed, there is the motion of Vice Chairman Coleman.
I'd like to recognize Vice Chairman Coleman for purposes of his motion. Vice Chairman.
Thank you, Chairman. I would ask that my motion be entered into the record as though I had read it in its entirety. Before the Commission for consideration and disposition is a joint petition for interlocutory review in answer to material questions filed by the Pennsylvania Office of Attorney General and the Pennsylvania Office of Consumer Advocate. The joint petition seeks review of an order addressing preliminary objections filed in response to a formal complaint filed by the OAG-OCA against Blue Pilot Energy, LLC. The formal complaint arose out of numerous customer contacts and complaints that were received related to the variable rates for electric supply service charged by Blue Pilot. My motion grants interlocutory review for two reasons. One, granting interlocutory review expedites the conduct of multiple formal complaint proceedings initiated by the Office of the Attorney General and the Office of Consumer Advocate. against EGSs relating to variable rates by ensuring that the material questions raised in the cases are decided consistently. 2, granting interlocutory review expedites the conduct of this proceeding by clarifying the scope of the Commission's subject matter jurisdiction and authority here, and by ensuring the development of the full and complete factual record in this case that is consistent with the Commission's jurisdiction and authority. Material question number 1 asks whether the Commission has authority and jurisdiction to determine violations of the Unfair Trade Practice and Consumer Protection Law and Telemarketing Registration Act. My motion answers this question in the negative for the reasons set forth in the ALJ order addressing the preliminary objections. Nevertheless, my motion also confirms the conclusion reached in the order that the Commission has jurisdiction to hear alleged violations of its own regulations. Material question number 2 asks whether the Commission has the authority and jurisdiction to determine whether the prices charged by an EGS conform to the EGS disclosure statement. My motion answers this question in the affirmative. I believe the Commission has jurisdiction and authority over the issues under Chapter 54 of our regulations, which requires that an EGS billed price reflect the disclosure statement. Therefore, I believe the Commission can determine whether Blue Pilot billed customers in accordance with the disclosure statement. Therefore, I move that the Office of Special Assistance prepare an opinion in order consistent with this motion, and that this matter be returned to the Office of the Administrative Law Judge for such further proceedings that may be necessary.
I second the motion.
Any further discussion? Any objections? Hearing none, the motion passes unanimously.
And it is recommended that the Commission adopt the final OSA item on page 21 with regard to the petition of LB Limousine Service, LLC.
So moved.
Second.
Any discussion? Any objections? Hearing none, the motion passes unanimously.
Turning now to matters presented on behalf of the Bureau of Technical Utility Services in omnibus fashion, we recommend the adoption of all items appearing on pages 22, 23, 24, and the first 2 items on page 25 through and including the application of Power Kiosk.
So moved.
Second.
Any discussion?
Yes, Chairman.
Commissioner Cawley.
First item on page 24, cloud computing concepts. I wish to concur in the result only.
So noted for the record here this morning. Are there any objections? Hearing none, the motion passes unanimously, noting that Commissioner Cawley will be concurring in result only in the matter involving Cloud Computing Concepts, LLC.
It is recommended that the Commission adopt the staff recommendation in the application proceeding involving Shentel Communications, LLC, noting the statement of Commissioner Brown.
So moved.
Second.
I'd like to recognize Commissioner Brown for purposes of her statement, Commissioner Brown.
Thank you, Mr. Chairman. I just would like to submit my statements for the record.
So noted. Any further discussion?
Yes, I wish again to be recorded as concurring in the result only on this matter.
So noted. Hearing no objections, the motion passes unanimously, noting Commissioner Brown's statement and noting that Commissioner Cawley is concurring in result only.
It is recommended that the Commission adopt the staff recommendation in the Price Stability Index Service Price Index proceeding involving the United Telephone Company of PA at the bottom of page 25, as well as all items appearing on pages 26. And the first item on page 27 in the proceeding involving Muirfield Energy, Inc.
So moved.
Second.
Any discussion? Any objections? Hearing none, the motion passes unanimously.
We recommend the adoption of the staff recommendation in the proceeding involving the application of DQE Communications, LLC, to provide services as a competitive access provider, noting the statement of Commissioner Brown.
So moved.
Second.
I'd like to recognize Commissioner Brown for purposes of her statement. Commissioner Brown.
Once again, Mr. Chairman, I'm just submitting my statement for the record.
Commissioner Brown, we appreciate your brevity here this morning. Any further discussion? Commissioner Cawley.
Yes, I wish again to concur in the result only on the matter of DQE Communications, LLC.
So noted. Any objections? Hearing none, the motion passes unanimously, noting the statement of Commissioner Brown and noting the fact that Commissioner Cawley will be concurring in result only.
Turning now to matters presented on the Law Bureau with regard to the first item at the top of page 28 with regard to the final rulemaking order involving motor carrier vehicle lists, age, and mileage requirements for taxis and limousines. There is the motion of Vice Chairman Coleman.
I'd like to recognize Vice Chairman Coleman for purposes of his motion. Vice Chairman Coleman.
Thank you, Mr. Chairman. I would ask that my motion be entered in the record as though I had read it in its entirety. In 2002, the Commission undertook a wide-ranging review of its motor carrier transportation regulations in order to conform to changes in federal law in the transportation industry. New regulations required taxicab and limousine companies to provide a list of all vehicles used in service and prohibited the use of taxicabs and limousines more than 8 model years old, except where a waiver had been requested and the Commission determined that the vehicle was safe and reliable. While these provisions were well-intentioned, our experience has demonstrated that modifications are needed. As we stated in our proposed rulemaking in this proceeding, the vehicle list requirement does not meaningfully aid in our regulations of carriers, and the waiver process consumes scarce Commission resources. In the proposed rulemaking order, we recommend eliminating the vehicle list requirement and the waiver request process for older vehicles. Separately, we propose that limousines be subject to a mileage limitation of 200,000 miles as opposed to an 8 model year limit. Comments filed by taxicab companies were generally opposed to maintaining the 8 model year while at the same time eliminating the waiver process. The Independent Regulatory Review Commission stated in its comments that this rulemaking that it agreed with the commentators that the elimination of the waiver process could result in severe consequences for small carriers. In the final rulemaking order, staff affirmed the recommendations of eliminating the vehicle list requirement and waiver process. Staff also proposes, in response to the comments received, to revise the limousine mileage limit to 350,000 miles. I agree with these elements of the recommendation. Staff also proposed to raise the model year limit for taxis that use alternative fuel to 12 years, which I agree with for the reasons outlined in the recommendation. However, I do not agree with the maintaining of age limit of 8 model years for non-alternatively fueled taxis, while at the same time eliminating the waiver process. I agree with the IRC that this may cause undue hardship to smaller carriers that serve smaller cities, towns, and rural areas, and affect the ability and affordability of the services in these communities. I acknowledge that the establishment of mileage and age standards for taxis and limousines is challenging in the absence of an accepted nationwide regulatory or industry standard. In 2007, the Taxicab, Limousine, and Paratransit Association did recommend an 8 model year limit for taxis in metropolitan areas of more than 1 million people. However, the TLPA acknowledged the standard would be unduly restrictive and costly for communities with smaller populations with less density. Based on a review of the comments and the other publicly available information, I propose that we adopt a standard that prohibits the use of a taxicab that meet either of the following conditions: are older than 10 model years for conventional vehicles or 12 model years for alternatively fueled vehicles, or vehicles having more than 350,000 odometer miles. I believe that this approach will reduce financial hardship for carriers while establishing a standard to serve public safety interests. A purely model year-based approach may result in taxis with 400,000 miles or more being used in service, which, accordingly to comments received, are on the road right now. A purely mileage-based standard could allow vehicles 15 or 20 years old to be used in service. While I agree that model years or mileage are not perfect indicators of vehicles' condition, a firm limit ensures that older vehicles without the latest safety features of substantial age and used related defects are retired from fleets within a reasonable period of time. The increase to 10 model years is a reasonable compromise given our decision to eliminate the waiver process, and a 10-year standard was suggested by some parties. However, the allowance of older vehicles must be tempered by reasonable restrictions on the level of usage. Accordingly, I recommend that we adopt a 350,000 mileage limitation on taxis we are proposing for limousines. It is my expectation that competitive market forces with increasingly work to prevent many taxis from reaching these limits and to provide modern, clean, and affordable, comfortable vehicles for their passengers. Therefore, I move that the final rule-making order as modified by this motion be approved and that the Law Bureau prepare a final rule-making order consistent with this motion.
I second the motion.
Any discussion? I simply want to take this opportunity to compliment the Vice Chairman. I think what you see here today is a motion that strikes the appropriate balance of recognizing geographic diversity across the transportation footprint here in the Commonwealth, and more importantly, working cooperatively with our transportation safety group to really strike the appropriate balance here today. And again, I compliment you for your efforts here this morning. It also speaks to the bigger issue that this commission has addressed in our efforts to modernize our transportation safety and transportation regulations to recognize changes within the marketplace. I think today's motion is a step forward in that direction. Any further discussion? Any objections? Hearing none, the motion passes unanimously.
It is recommended that the commission adopt the staff recommendation in the proceeding involving the eligible telecommunications carrier designation of Buffalo Lake Erie Wireless Systems at the bottom of page 28, as well as the first two items on page 29 through and including the petition for reconsideration involving the commission's order involving Lyft Inc.
So moved.
Second?
Any discussion? Any objections? Hearing none, the motion passes unanimously.
At the bottom of page 29, with regard to the matter involving the Pike County Light and Power Company request to waive the commission's accelerating switching regulations, there's the joint motion of Commissioners Whitmer and Brown.
I'd like to recognize Commissioner Whitmer for the purposes of the joint motion here this morning. Commissioner Whitmer.
Thank you, Mr. Chairman. I'd like my statement, or our joint motion rather, entered into the record as if we'd read it in its entirety. Before us today is the petition of Pike County Light and Company for waiver of the Commission's accelerated switching regulations. Pike requests a waiver from the regulations requiring EDCs to switch a customer's electric generation supplier within 3 business days of enrollment. Pike makes this request based on the costs of upgrading its information technology systems as well as the relative size of its customer base. Pike has not proposed an end date for its waiver request, but did offer an alternative which would reduce the switching timeframe to 9 days. As part of the basis of its waiver request, Pike provided data that 74 customers switched suppliers in 2013 and 91 customers switched in 2014. It also estimated that IT changes would cost $619,000 to implement the accelerated switching over the next 18 months. However, Pike provided no data on the costs, requirements, and feasibility of performing switches in a non-automated or manual manner outside of the normal system requirements. Given the fact that over the last 2 years, Pike has performed on average less than 8 switches per month, we feel a manual process to switching customers faster holds promise as a potential solution to Pike's concerns. While we understand the costs and effort Pike must undertake in order to comply with our regulations, our disposition in this instant proceeding is guided by the principle that Pike's customers should not be treated differently and be afforded the same ability to switch as customers throughout Pennsylvania. Therefore, we propose that Pike be granted a 6-month waiver from the Commission's accelerated switching regulations. In addition, within 90 days from the entry date of this order, we propose Pike be directed to file with the Commission an analysis of a manual process that complies with our regs and would not warrant significant changes to existing IT infrastructure. If Pike determines that it requires an additional waiver of the Commission's regulations, the company may timely file such a request before the expiration of the 6-month waiver granted today. Therefore, we move that the petition of Pike County Light and Power Company be granted for a 6-month period, and that the Office of Special Assistance prepare and order an opinion consistent with this motion. Thank you, Mr. Chairman.
Second?
Any discussion? Any objections? Hearing none, the motion passes. The joint motion passes unanimously.
Continuing with matters on behalf of the Law Bureau, on page 30, it is recommended that the Commission adopt both recommendations there appearing through and including the recommendation pertaining to Yellow Cab Company of Pittsburgh and Ray Cab Company, LLC.
So moved.
Second?
Any discussion? Any objections? Hearing none, the motion passes unanimously.
Turning now to matters presented on behalf of the Office of Administrative Law Judge, with regard to ALJ Jones's initial decision in the proceeding involving Kevin Washington versus Philadelphia Gas Works, there is the motion of Commissioner Brown as well as the statement of Commissioner Whitmer.
I'd like to recognize Commissioner Brown for purposes of her motion. Commissioner Brown.
Thank you, Mr. Chairman. I ask that my motion be entered into the record in its entirety. Before the commission is the initial decision of Administrative Law Judge Angela Jones pertaining to Kevin Washington's complaint against Philadelphia Gas Works. In this case, the company offered to reinstate the complainant's payment arrangement if a $700 payment was made. The complainant complied with PGW's request. However, the company subsequently disconnected service for the complainant. The ALJ in this proceeding denies the request for reinstatement on the complainant's payment agreement and recommends sending the case to the commission staff for further investigation into a potential civil penalty. I must respectfully disagree with these recommended outcomes. I believe that equity demands that PGW live up to its end of the bargain. I understand that the complainant has the type of payment history which would normally prevent this commission from ordering a payment arrangement. However, reinstatement in this case does not constitute a commission-ordered payment arrangement. Rather, it involves rectifying an unreasonable business practice and making PGW deliver on a promise made to a customer. As well, I believe that a presiding officer has the authority to determine if a fine is necessary and in the public interest, and if so, what amount would be prudent. If further fact-finding is deemed necessary, a hearing should be held. Therefore, I move that the initial decision of ALJ Jones be reversed in part and that PGW be directed to place the complainant back onto the April 15, 2013 payment arrangement. 2, the topic of whether a fine is necessary and in the public interest be remanded to the Office of Administrative Law Judge for disposition and/or further proceedings as may be necessary, consistent with this motion. And 3, the Office of Special Assistants prepare an opinion and order consistent with this motion.
Second.
Any discussion? Like Commissioner Whitmer for purposes of her statement. Commissioner Whitmer.
Thank you, Mr. Chairman. And I'd like my statement entered into the record as if I'd read it in its entirety. Before the commission is the complaint of Kevin Washington against Philadelphia Gas Works, which alleges that PGW disconnected service after he paid $700 that was required by the company to avoid termination and to reinstitute his payment agreement. I'm supportive of the motion offered by Commissioner Brown today, as the agreement offered by PGW is well documented in this case. However, it is not lost on me that Mr. Washington has an abysmal payment history. Since 2003, the complainant received 30 payment arrangements and defaulted on 27 of them. When his service was terminated in August of 2013, the complainant owed PGW almost $3,000 for service he previously received. PGW negotiated an agreement with the complainant that a $700 payment would avoid termination and reinstate his prior commission-issued payment agreement, and I firmly believe that PGW must honor that arrangement. However, this resolution is essentially a lucky break for Mr. Washington, given his prior payment history. I would highly encourage the complainant to make timely and full payments to PGW under his payment arrangement so that PGW is appropriately compensated and other customers are not unfairly burdened with higher rates due to the uncollected costs in this case. Thank you, Mr. Chairman.
Thank you, Commissioner Whitmer. Any further discussion? Any objections? Hearing none, the motion passes unanimously.
It is recommended that the commission adopt ALJ Melillo's initial decision in the proceeding involving Sandra Hopley versus Pico Energy Company Electric.
So moved.
Second.
Any discussion? Any objections? Hearing none, the motion passes unanimously.
With regard to ALJ Hoyer's recommended decision in the general rate increase proceeding involving Columbia Gas of Pennsylvania, Inc., there is the motion of Commissioner Whitmer.
I'd like to recognize Commissioner Whitmer for purposes of our motion here this morning. Commissioner Whitmer.
Thank you, Mr. Chairman. I'd like my motion entered into the record as if I'd read it in its entirety. Before the commission today is the recommended decision of Administrative Law Judge Hoyer approving a settlement between Columbia and various parties related to a tariff supplement filed by Columbia on March 21st of this year. The settlement includes rates designed to produce an additional $32.5 million in annual base rate operating revenues. While I'm supportive of the settlement in this case, I propose a clarification regarding the terms of the agreement. In order to reach agreement, the parties in this case did not identify the specific ROE for distribution system improvement charge computation purposes. However, under the DISC Act, Act 11 of 2012, it requires that companies using a DISC calculate depreciation using the ROE calculated in the utility's most recent base rate proceeding, or if the proceeding was over 2 years ago, using the rate calculated by the Commission in the most recent quarterly report on earnings of jurisdictional utilities. Because there is no clear statement of equity return rate for DISC computation within this base rate proceeding, I recommend that the company use the rate calculation instituted in our approval of Columbia's DISC petition. In that proceeding, Columbia's most recent base rate case also did not contain a specific ROE for DISC computation purposes. Rather than adopt an estimated return on equity proposed by Columbia, the Commission directed the company to use the current staff quarterly report in order to calculate the ROE for DISC. I see no reason to change course here and recommend that Columbia use the most recent quarterly report in order to set its ROE for DISC. I also want to clarify that on an ongoing forward basis, Columbia should update its ROE for DISC purposes consistent with any changes to the ROE in the quarterly report. In addition, the parties to the rate case proceedings are reminded that in accordance with Section 1357B2 of the Public Utility Code, and consistent with our DISC implementation order, rate case settlements are to include a stipulated ROE for calculation of DISC. Therefore, I move that the Office of Special Assistance prepare an opinion and order consistent with this motion.
Second.
Any discussion? Any objections? Hearing none, the motion passes unanimously.
And on page 32, with regard to ALJ Salapa's initial decision in the proceeding involving Joseph Nadav versus Respond Power LLC, there is the motion of Vice Chairman Coleman.
I'd like to recognize Vice Chairman Coleman for purposes of his motion. Vice Chairman Coleman.
Thank you, Mr. Chairman. I'd ask that my motion be entered in the record as though I had read it in its entirety. Before us is a formal complaint brought against Joseph Navda against Respond Power LLC, a licensed electric generation supplier. In this complaint, Mr. Navda alleges that Respond charged his business an excessive rate for the supply of electricity for a period of time earlier this year, and that his rate be recalculated and a refund provided. The presiding ALJ granted the preliminary objections, finding that the Commission lacked jurisdiction over EGS rates and that the complaint was legally insufficient. I agree with these findings of the ALJ in the decision that dismissed the complaint. However, I do disagree with one statement made in the text of the decision. The ALJ stated that because the Commission lacks the authority to regulate rates, it also lacks the authority to order a refund or credit to be provided to the complainant. I do not agree with this characterization of the authority to order refunds or credits. The Commission has interpreted the Public Utility Code to find that a refund is an appropriate remedy when a customer's supplier has been charged without the customer's affirmative consent. The Commission promulgated regulations that require an EGS to provide a full refund to customers for all generation charges resulting from an unauthorized switch. Accordingly, while I agree with the Commission's lack of authority to regulate EGS rates, it is well settled that EGSs may be required to provide refunds to retail consumers in appropriate circumstances. Therefore, I move that the Commission adopt the initial decision as modified by this motion, and that the Office of Special Assistance prepare an opinion and order consistent with this motion.
Second.
Any discussion? Any objections? Hearing none, the motion passes unanimously.
Mr. Chairman and Commissioners, that does conclude the presentation of regular agenda items. Turning now to the carry-in agenda, we will take the second item first. With that having been said, we recommend the adoption of the staff recommendation with regard to the petition for interlocutory review involving whether or not certain trip data should be released in the proceeding involving the PUC's Investigation and Enforcement Bureau versus Lyft, Inc.
So moved.
Second.
Any discussion? Any objections? Hearing none, the motion passes unanimously.
We will take the first item on page 1 as well as the item appearing on page 2 in tandem now, those pertaining to the application of Rasier-PA LLC with regard to the right to begin to transport by motor vehicle persons in experimental service in Allegheny County in the first application, as well as between certain points in Pennsylvania in the second application, noting the combined joint motion of Commissioners Whitmer and you, Mr. Chairman, as well as the combined statement of Vice Chairman Coleman and the combined statement of Commissioner Brown, the combination being between the two identified proceedings.
Thank you. I'd like to first start by having the combined statement offered by Commissioner Whitmer and I combined motion entered into the record as if read its entirety. The pervasive use of smartphones and the internet has revolutionized various sectors of our economy. One such example is the creation of transportation network companies. TNCs, as we all know, are altering the space traditionally occupied by taxi cabs, and the difference is much more than reinventing dispatch methods. The most fundamental change between TNCs and traditional taxi cab service is the contractual use of private personal vehicles and drivers to carry passengers rather than ownership of vehicle fleets by a certificated holder. This innovative use of the public space should be encouraged in a way that is consistent with the Commission's mission to both protect the public interest and foster new technologies, and do it without sacrificing safety, which is first and foremost in any application we approve at this Commission. Thus, we consider the experimental application of this service and the move to grant Rasier-PA statewide and Allegheny County applications for experimental subject to certain conditions attached in Appendix A of this motion. Uber Technologies, Inc. has created an internet-based platform to connect passengers and drivers. Uber asserts that it is a travel website like those offering online scheduling of hotels, car rentals, or airlines, or examples, Priceline, Expedia, Orbitz, etc. Respectfully, we disagree. Uber does much more than simply providing reservations for rides. Uber One dispatches software that matches the rider with the driver. It establishes contractual agreements with both drivers and passengers. It engages drivers as independent contractors. It sets forth the fare for each trip. It collects fares from passengers, charges drivers for overhead costs, remits drivers' share of the proceeds, arranges insurance for the on-duty private vehicles and their operation. And it also sets minimum vehicle and driver standards. And last, it addresses a whole host of other operational concerns that make the service work. Uber has requested that a wholly owned operating affiliate, Rasier-PA, be certificated to provide experimental service by this Commission. The Rasier-PA will lease operating rights to the software offered by Uber and utilize Uber-provided services, which include insurance, driver checks, etc. And Rasier-PA has no employees. Rather, as its parent, Uber has assigned employees and some independent contractors to launch the service in the greater Allegheny County area. Subject to certain conditions, we believe that this new type of transportation service can be of great benefit to the traveling public and should be certificated by this Commission. Given the myriad of differences between TNCs and traditional taxi cab in the traditional taxi cab industry, we do so on the basis of experimental authority, which grants operating rights for 2 years. This 2-year time frame, we believe, is appropriate given the dynamic and the evolving nature of the TNC business model here in the Commonwealth of Pennsylvania. In the meantime, I think it's absolutely critical, and the intent of this Commission is to continue to work with the General Assembly on passing legislation that creates a new category of passenger service designed to recognize the TNC business model and refine the regulatory approach we take here. And I think all my colleagues would join me in commending State Senator Wayne Fontana and the efforts that he's taken in reaching out to this Commission in terms of adopting legislation to address this void in the marketplace. Most of the conditions that we're adopting today not only largely mirror our regulations, but also Rasier-PA's existing operating practices, such as vehicle inspection, driver background checks, zero tolerance for drug and alcohol use while operating a vehicle, and meeting insurance requirements as well. And I simply would remind this particular applicant that this is all great that you have this, quote, self-policing model in place now, but as you work towards a 2-year compliance schedule, you will do this with transportation safety officers at the commission. Rasier-PA has committed to provide primary liability insurance coverage for all vehicles operating on its platform. From the time the app is open and the operator has logged onto the system, which is known as the Stage 1 application, until the service has been completed, which is the Stage 3 application, we agree that the coverage that has been provided in a Form E document with the Commission is adequate and is in compliance with our regulations. However, in other vital areas, we require Rasier-PA, and hence Uber, to achieve more than they have proposed in their application. We are concerned that Uber drivers may not understand that this commercial use of their personal vehicles could void their existing personal vehicle insurance, which otherwise apply when their vehicle is not being used for TNC purposes. And let me just say, this simple disclosure will go a long way in creating, I'll say, goodwill, not only with the commission, but more importantly, that these drivers, and it's great, as I said earlier in this joint motion, we recognize that this technology is coming into the transportation space, but the liability and exposure associated with these drivers if they were to get an accident, and the fact that they are not they have not notified their primary insurance carrier does create an issue. While the assimilation of TNC operations into the vehicle insurance market is ultimately a question to be resolved by the insurance industry, and I think we recognize this here today, and I want to commend through our en banc proceeding Mr. Marshall, who represents the Insurance Federation of Pennsylvania, that there needs to be an evolution within the insurance marketplace to provide this Stage 1 coverage. And I think, to the credit of Senator Fontana, this could be articulated as the California General Assembly recently did in codifying some new level of insurance requirements for the Stage 1 app of the service. And again, we encourage and support efforts by Uber, Rasier-PA, and the auto insurance industry to create this product to prevent any gaps in coverage. While we are proposing to conditionally grant, and I want to stress that, conditionally grant Rasier-PA's application, we acknowledge that Rasier-PA's compliance with our prior orders and regulations has been uneven, to say the least. And I could go a little further than that here this morning, but I'll temper my message and my words. In connection with its emergency temporary authority in Allegheny County, Rasier-PA has filed the requisite Form E certificate, as I mentioned earlier, certificate, Form E and certificate of insurance, and an acceptable tariff with the commission. However, Rasier-PA has not yet demonstrated compliance with several important conditions to the EPA that were set forth in the July 24th order. For example, Rasier-PA did not comply with the ALJ's interim order requiring the production of certain trip data. Therefore, in the order to obtain a certificate of public convenience from the Commission, we are also requiring that Rasier-PA, as part of the compliance filing here this morning, submit that requested trip information. And I don't know why they're overcomplicating this request. Any other issues related to noncompliance with the ALJ's July 31st order is therefore referred to the Commission's Bureau of Investigation and Enforcement for such further action as deemed appropriate. We have fully reviewed Rasier-PA's ETA history, as well as the record in this case, and we have shaped conditions that allow for this exciting new business model to thrive here in the Commonwealth of Pennsylvania, while at the same time ensuring that the necessary public protections are in place. Therefore, the authority we move here this morning is to grant, it shall not take effect, until Rasier-PA has demonstrated full and complete compliance with the conditions set forth in Appendix A. If Rasier-PA rejects these conditions, along with any affiliates, they shall no longer be authorized to provide service here in the Commonwealth of Pennsylvania. And therefore, we move that the application of Rasier-PA LLC for motor carrier of persons in experimental service in the counties requested in the above referenced dockets be approved. The Transportation Authority will be for a period of 2 years from the issuance of certificates of public convenience and is subject to the terms and conditions set forth in Appendix A. Rasier-PA LLC will not engage in any transportation in the Commonwealth until its compliance plan is approved and a certificate of public convenience is issued by the Commission, with exceptions of the emergency temporary authority that was granted in the order entered into the docket on July 24th of this calendar year. Last, that the Office of Special Assistance prepare an order in opinion and order consistent with this motion.
I second the motion.
Thank you. Now I'd like to recognize, Vice Chairman Coleman for purposes of his combined statement. Thank you. Vice Chairman Coleman.
Thank you, Mr. Chairman, and I would ask that my statement be entered into the record as though I had read it in the entirety. First, let me begin by thanking the staff, particularly our Law Bureau staff and our staff in investigation and enforcement. This has been a piece of business that has been on our plate for many, many months, and I appreciate all of the hard work that the teams have done to get us to this point this morning. The second point that I'd like to make is this has always been about safety. It's been about safety from the beginning, and it's about safety today on 3 different aspects. It's about driver safety, it's about vehicle safety, and it's about insurance. I'm in general agreement with the presiding administrative law judge's recommended decision on these matters. Transportation network companies have great potential to meet public need for efficient, consumer-friendly transportation options. I agree that the proposed service falls within the definition of public utility service and is subject to our jurisdiction. I also conclude that the applicant did not meet its burden of proof in showing that it was fit to provide the service at this point in time. Specifically, I'm gravely concerned about the safety of drivers, passengers, and other members of the public will be unnecessarily compromised under the applicant's current business model. I appreciate the majority's well-intentioned effort to bring the applicant into accord with the reasonable safety and insurance requirements by making the granting of permanent authority contingent upon compliance by a certain date. However, I am very skeptical that the applicant will satisfy these conditions. The applicant commenced operation with a certificate of public convenience despite Commission advice to the contrary. It continued to operate even after the issuance of a cease and desist order. It was then provided a path to compliance when it was granted emergency temporary authority in July of this year, and that ETA was later extended. Insurance-related conditions for the ETA have never been fully satisfied. If the applicant had been sincerely interested in avoiding the enforcement actions by our Bureau of Investigation and Enforcement, it could have resolved these issues before it started operation. Instead, it is apparent that the applicant views the proceedings before the Commission as a lengthy negotiation process. Any public safety or insurance requirements that conflict with its business model are inconveniences that will be ignored. Any financial sanctions we impose or negative consequences experienced by the public during the period are cost of doing business. I do not believe the applicant will take the necessary steps to ensure its service is safe and reasonable until it is forced to do so by a court in this Commonwealth, and as a result of legislative action. Therefore, I respectfully dissent this morning.
Thank you, Vice Chairman Coleman. Now I'd like to recognize Commissioner Brown for purposes of her combined statement on this case. Commissioner Brown.
Thank you, Mr. Chairman. I am supportive of your motion. Rasier-PA LLC seeks commission approval to provide experimental service of shared ride network for passenger trips between points in Allegheny County as well as statewide. I believe that this type of service can be beneficial to the public, especially in underserved areas throughout the Commonwealth. This commission is certainly not against new or innovative services, but we have a responsibility to uphold the laws as they are currently written. That being said, the success or failure of the transportation network companies such as Rasier depend solely on their propensity to operate safely within the confines of our laws. Their conduct over the next few months will establish its future operations here in Pennsylvania. If it chooses not to comply with the regulatory requirements established in this order, I will not be hesitant to seek further enforcement action. Thank you.
Thank you, Commissioner Brown. Now I'd like to recognize Commissioner Cawley for his combined statement. Commissioner Cawley.
Thank you, Chairman. I would like to compliment my colleagues on their effort to bring a beneficial and innovative change to taxi service, particularly in the city of Pittsburgh. But innovation alone is no excuse for ignoring the law, any more than a new and innovative way to rob banks should be encouraged and condoned. This applicant doesn't seem to understand that, and in fact has a business plan which is intentionally violative of the law. I therefore couldn't agree more with the Vice Chairman's statement. I have been persuaded, however, very reluctantly, to once again, as I have with the emergency temporary authority that we have granted to this applicant, to give this applicant a final opportunity to abandon its anarchist ways and to finally become a responsible, lawful corporate citizen in this state. But let me put it in plain English to Uber. This is your last chance with this commission. We've had it. Our patience is exhausted. You're either going to have to comply this time, or the next stop is going to be the Commonwealth Court of Pennsylvania, and you can try thumbing your nose at a court of law with the spurious, disingenuous arguments that you've presented to us and see where you get with a court of law. So, for those who are reporting on what we're doing today, let's be clear. We are not granting permanent authority to Uber today. They are going to have to demonstrate to us within 30 days that they're going to finally comply with our lawful orders to protect the public safety. At the end of 30 days, if they don't come up with the trip data that we've previously ordered, if they don't agree to abide by the Commonwealth's automobile safety standards, and if they don't abide by the other conditions we have placed on this order, then what we do today will mean nothing, because we will likely very shortly enter a cease and desist order, which, if disobeyed, will lead us to ask the Commonwealth Court to enforce the law. So it's up to Uber at this point. Now, having said that, there is one part of this that still concerns me very much, even with the conditions we've attached. We do not have jurisdiction over the drivers. unlike a normal taxi cab company where they are employees of the taxi cab company and the drivers can be made to comply with whatever we tell the company to do. The drivers are independent contractors, and therefore we can require Uber to tell the drivers to tell their insurance company that they're using their vehicle for a commercial purpose. So far, the insurance industry does not have risk data enough to price adequate insurance policies, but they're going to. It's likely that if an individual is going to use a personal automobile for a commercial use, the premium is going to be higher. Many drivers are probably going to sign off and say they've told their insurance company that they're using the car for Uber, when in fact they won't. And someone is going to get hurt, either the driver or a passenger or a pedestrian or some other third party, and there will be no coverage. Because as the chairman indicated, under that circumstance, if you use a personal automobile for any commercial purpose, the policy is voidable. So even if the individual is not using the vehicle for Uber and may be simply using it for its personal reasons, and there's an accident, the policy could be void already. So once again, it's up to you, Uber. You either comply this time, or I'm telling you, my patience is exhausted, all of our patience is exhausted. This is your last chance.
Hearing no further statements, I believe we have a second on the joint motion. Commissioner Cawley?
I did.
Okay, and noting the combined statement of the Vice Chairman, Commissioner Brown, and more recently, Commissioner Cawley. And the vote on this matter is 4-1, noting the dissent of the Vice Chairman, which I'm respectful of his position, because let me just say, I remain skeptical as well, and I'm man enough to admit it here this morning. And with that, the vote is 4-1. And let me conclude with one point. I look out to Buck Pankew and the staffs, Commissioner Whitmer, all of our staffs that work collaboratively on this. This is, I agree with Commissioner Cawley, this is the last hurrah for Uber to comply. To quote the great Taylor Swift, I'm exhausted. This is exhausting. I'm done with it. And I think she used that in the song, and I too am exhausted by it. And I hope that we can move on to more prevalent matters in the coming months. But Buck Pankew, a true shout out to you and your team for the constructive nature and the way you rallied this commission to address this issue. And I say that respectfully because you are one of the unsung heroes, and we owe you a big thank you here this morning. With that, we're going to adjourn public meeting.